We're preparing to go live right now, and Vice Chair Guyton is in the waiting room. Okay,
Great.
I just let her in. Okay, we are live.
Okay. Good afternoon, everyone. Welcome to the March 18th meeting of the Environment Subcommittee. Thanks, everyone, for joining. We have two bills to consider. HB 925, which we talked about at our last meeting, and HB 1219. So, Kristen, could I ask you to start with HB 1219?
And Mr. Chair, would you like me to bringing up the reprint of House Bill 1219 on my screen?
Yes,
I
please.
hope it was a
Share
lot
screen.
better than your ship. Oops.
Okay. All right. So this is House Bill 1219, which is requiring the University System of Maryland to conduct a study to evaluate the relationship between climate change, the availability and price of homeowners insurance, and emergency and disaster preparedness. The next few lines list the membership of the study is to be done in combination and oversight with legislative members, state agencies, and local representatives. On page 2 of the bill, subsection C lays out the requirements of the study or what the study must evaluate. Do we read through all those? Do you want to stop and read?
No, that's okay. I mean, after you do your summary, I'll ask the good sponsor, Delegate Fraser Dalgo, to comment and provide any background he would like on the bill.
Okay, and so in line 16 here, we do have an amendment from the sponsor that would delay the report. The bill as introduced would have required University of Maryland to report back by January 1st, 2027. This pushes it to July 1st, 2027. And so this lays out the contents of the report and recommendations also must be made. And then we have language that we add, new subsection E, that would authorize up to $100,000 of money in CEF to be used by the University of Maryland to conduct the study that's required under the bill.
Okay. Okay. Very good. And Delegate Fraser Dalgo.
Yeah, sure. I don't want to rehash the the hearing, but suffice to say that this, I think, is a priority bill from a couple different perspectives, not simply mine, but when I went over to ECM, I became the chair of the Property and Casualty Insurance Subcommittee and learned a lot in those 3 years about it, and just a lot of concerns with insurance companies and potentially leaving the state. Some other states, I think, are in danger of that when it comes to just extreme weather events, which is one piece of the bill. So I think that's very important to make sure we don't lose our property insurance, and that we, build back stronger and better sometimes when we have these events. But the real piece of the bill that is, and that's not to say that's not important, but the part that's really super important is the FEMA piece. And we all know that what happened in Western Maryland and a failure for FEMA to come in and help or reimburse in Western Maryland, despite the fact that they qualified for FEMA relief, is very, very concerning, especially specifically when it comes to the fact that the current administration has said in multiple occasions that they intend to pretty much pull FEMA out of the states and not help. And that's concerning because as we have disasters, whatever disaster they may be, we depend, as the other states depend on the federal government. And if the federal government's not there, that's a really big problem. And we need to plan for that. If that's what's going to happen, then we as a state, we need to get all the experts in the room on disaster preparedness, and we need to figure out how we're going to move forward if FEMA is not going to be there. And that's what the administration is saying, and that's what they're showing across the country. And it just is very, very, you guys probably remember the bill hearing. It's very scary to me that if we don't have a plan and we don't have resources to help people. And the recent one we just saw was in Western Maryland. That's it. That's the whole point of the bill.
Okay, all right, thank you, Delegate. Delegate Baylor,
The amendment.
I'm sorry, you're moving the amendment?
Yeah, move the
Okay.
amendment.
Is there a second?
Second.
Okay, any question about the amendments? Okay, all those in favor of the amendment say aye.
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 Opposed? Okay, the bill as amended. Is there a motion?
Move the bill as amended.
Second? Okay. Any final questions about the bill? If not, all those in favor of the bill as amended, say aye.
Aye.
Opposed?
Opposed.
Okay. Any abstentions? All right, very good. The bill passes as amended. Okay, on to House Bill 925, PFAS. Just to sort of remind everyone what we did, was it Monday that we met? Losing track of time here, but we did a review of the amendments to the Senate bill as approved by the Senate, to the Senate cross file, and which amendments I support. We have two of the things, I mean, in considering amendments, which we'll get to sort of one at a time in terms of deciding which ones we want to incorporate. There are two, well, there's Delegate Grammer has an amendment, and then there's an additional amendment that that I'm going to recommend. Before we get to that additional amendment, Delegate Grammer, I know you submitted amendments. And Kristen, could you pull up those amendments that the Delegate Grammer has proposed?
Sure.
And if you could do a quick summary of them, and then I'll ask Delegate Grammer to elaborate.
Yes, thank you, Mr. Chair. So my concerns initially with the bill were that it didn't actually limit the application of PFAS really in a way that protects the health of the end user, of someone who might purchase food from a farm to which these biosolids were applied. And there's a lot of concerns that the bill as drafted may fail to cover a significant portion of the actors responsible for contributing to the generation and spread of PFAS contaminated sludge. So as you know, we have a practical problem here. We have to do something with the biosolids. The alternatives are, incineration or burying them, which financially didn't seem to be an option right now. And the question is, what do we do knowing that we're essentially allowing the application of biosolids, which don't limit the parts per billion in a way that we know, we're not adhering to the federal standards. And we know that there are, frankly, it's a health concern. And the biggest PFAS lawsuit is actually here in Maryland. So what my amendment attempts to do to address that is apply appropriate civil liability standards. And it essentially says that if someone is harmed by the application of PFAS, that there will be liability for that. And we know we can't nip this in the bud statutorily, but what we are making clear to the participants, and this is a market, these biosolids, there is a market here. People are making money distributing this. We are making it clear to them that if these biosolids are applied in a way that these PFAS end up harming someone, and that's proven in court, that there will be liability for this. And typically when there isn't a statutory framework which, nips one of these, environmental health care concerns in the bud, civil liability is frequently how these types of situations are handled. So I think we should, knowing that we can't pursue one of these other options, incineration or burial, knowing that we can't practically adhere to the federal standards for PFAS parts per billion, I think this is a great option for ensuring that if someone does suffer a health-related injury due to PFAS, that the players are going to be held accountable. With that, I'd offer that amendment to the subcommittee.
Okay, thank you, Delegate. Delegate Holmes, do you have a question?
I was going to ask the question, Mr. Chair, but I don't know if you want to go through the proper procedure and have someone move the amendment, and then if there's a second, then we ask questions. But I did have a question on the amendment. I will wait for your.
Yeah, why don't you ask questions now?
Okay.
And then what we're going to do is after, any questions about Delegate Grammer's amendments, we're going to go through. Well, there was one small amendment which I'll ask Kristen to discuss, which is new, and then we'll start from the top, which is the amendments that we discussed a couple days ago. See if there's motion for that. Anyway, so at that
Sure.
point, we'll consider them through motions.
With that being said, Mr. Chair, I have a question to Delegate Grammer in terms of this amendment. There's some liability being discussed in this amendment. Who is liable and who is liable for this? And currently, I think that some of this disposal of these PFAS are allowed by state law, I think. So are you including liability with the state as well? So who is liable, basically, is the question.
Thank you. So this expands the liability to not only, the parties who are selling, but also the parties that are moving. And the reason for that is, and I consulted with one of the firms that handles this PFAS litigation, is that it was mentioned that in committee, some of the states that prohibit the use, the end result, I asked the question, well, what do they do with the product? And they said, well, they just ship it to another state. So this is structured in a way that covers, frankly, all of the industry actors that are in the industry of generation or, I guess, relocating sludge that has PFAS in it.
If I could have a follow-up, Mr. Chair.
Sure.
Would the state be included in this liability lawsuit in any way?
No.
Thank you, Mr. Chair.
Okay. All right. Delegate Guyton.
Thank you so much, Mr. Chair, and thank you, Delegate Grammer, for bringing the amendment. I think we have some of the same concerns about the fact that, really no level of PFAS is safe, particularly in agriculture or being dumped on our farmland. I'm not sure what my question really is, because this is a lot to process, and I'm not sure that this isn't overly broad. I guess I wanted to ask Kristen whether legally this is a provision, that we can even really put into state law. I'm just trying to figure this out. It's really, really broad. I would love to have seen an amendment that would have, lowered the percentages or, parts per billion, or put more restrictions on it. But this legal remedy, I'm not sure, A, I totally understand the implications of, and B, that I'm not sure is like the right way to do it. But I'm happy to be convinced if somebody wants to try.
So I would say first, as far as application, in Title IX, Subtitle 2, where this is drafted, the definition of person includes the federal government, a state, county, municipal corporation, or other political subdivision. So the language that's drafted here, which is applying liability, is to a person. So that would apply to the state.
Sorry,
Just
I had to
hold on.
step
If
out for a
Delegate
second. I'm
Grammer
sorry.
can,
Don't.
I'm sorry, Mr. Chair.
Yeah, no, I'm sorry. I had to step out for 15 seconds. So,
Oh, okay.
but okay. So, Kristen, you were able to respond to that.
Well, she responded to
Kind
the
of.
first question, but I guess I'll give Delegate Grammer another. And, my attention span maybe isn't as long as yours, sir, but if you can make it really brief in a way that I can understand, why is this the best way to address this problem?
Delegate Grammer.
Yes, thank you. And those are great questions. I'll address Kristen's comment first. That is the correct definition of a person, but I will also note as a matter of practice, the state or federal government, they don't actually participate here. So at the end of the remediation at a wastewater treatment plant, you might have heard of the Synagro facility. It's kind of the final step at the Back River plant. It's an industry partner. And from that point, they, allow people to export the biosolids from the plant. It's kind of the final step for the physical component of the remediation at the plant. And of course, you have the vapor and the effluents, but that is the final step, and that is a private company. So while the definition of person might include the government or the federal government or the state, neither of those actually participate in this industry. As far as Delegates Guyton's question, so I come from the Civil Law Subcommittee, and maybe this is just me using my judiciary chops, but you have to consider, as lawmakers, what is the best way to handle this problem? And I'm with you. In my lawmaker brain, I'm going, well, you tweak the parts per billion down. But as you know, practically, we can't do that because it would essentially seize the ability of the industry to do this at all. So the idea for this came to me knowing that right now, like this is the whole problem with the bill right now, right? We want to numerically tighten the parts per billion down, but as a matter of practice, the biosolids couldn't be distributed at all. Like it would be impractical. So as lawmakers, what do you do to make it clear that this has to be done safely? As a practical measure, for me, coming from the civil law subcommittee, you make it clear that as the industry is doing this, they understand clearly that they are liable if the biosolids are not mixed in a way where it's parts per billion that are safe for people.
Sure.
Now,
And I think my question really is, so if I felt like I was being harmed by this, or I found someone breaking the law by doing this, and then there was harm, which is required here, wouldn't I already be able to sue that company?
and this is important. This is why I spoke with the firm who handles this litigation. The answer to your question is maybe, because it does not, as drafted, the law does not actually cover all the players of the industry, for one. And it does not make clear how this applies in terms of liability. So, in common law, technically there is a liability. But if the bill passes as drafted, these folks could very well say, well, I was acting within the law. And as the case plays out, they were just acting within the law. They did what we told them to do. And I think maybe why, Delegate Guyton, why everybody on that committee testimony sheet was in favor of the bill is it created a statutory framework which made the unhealthy distribution of PFAS legal. That is my underlying problem with the bill.
Okay, thank you for that explanation. I'm going to let somebody else have a chance while I process.
Thank you.
Okay, Delegate Anderson.
Yes, thank you, Mr. Chair. This really brings a point to me that I had trouble with the bill because the way the bill was going to be presented to the agriculture community was we're guaranteeing you this product. You can use it, no problem. We've taken care of it. But there were no checks and balances. Nobody was testing each load. They said they were testing a tank. Well, a tank at one of these facilities could hold 20 loads, and it could settle out. And what's in the bottom of the tank be drastically different than the sample they pull off the top. And it really gave me a scary feeling that they were really legitimizing the handling of this product, and they're not. And it also gave me concern that they financially benefit from getting rid of this stuff. So if they've got a higher content than they can get rid of, they're still going to find somewhere to get rid of it, and buyer beware. And that's what the agriculture community has been standing on, buyer beware. But this legitimizes it and makes the farmer feel like someone else is, there's an intermediary here that's helping us regulate this, so I don't have to worry about it. And that's just that's false. So the amendment means a lot to me. It would probably make me vote for the bill, but before I was really concerned about the liability, because the liability all came back on the farmer. Everybody in the chain profited, but all the liability ended up with the farmer. Thank you.
Okay, thank you, Delegate. Zach Schaefer with MDE. I see you're on the call. Would you like to comment?
Thanks, Delegate Stein, Delegate Grammer, Delegate Anderson. Thanks for those comments too. I really appreciate where you're coming from on this. What we tried to do as we talked with both industry and the advocates, including farmers over the last year, was to strike a balance that would provide certainty that exposure pathways are being reduced. Know that the technology isn't out there to eliminate PFAS in biosolids, at least not economically and practicable. But this provides for those guardrails. I do this would have the effect of quickly ending the practice of land application of biosolids, which would have consequences for how biosolids are managed in the state that would have knock-on effects to landfills, to to county government, to the farmers themselves who do use the product and depend on it as a low-cost fertilizer. I'm also concerned with how the amendment would be implemented with respect, not with respect to the department so much as with just the way that PFAS health risk works. It's not possible to really attribute, what the health impacts of, say, exceedance of 26 parts 25 per billion versus 1 billion. It's our contributions to these adverse health outcomes, but it's very, very difficult to attribute a health outcome to a specific level of PFAS, just because of all of the different exposures to PFAS that we'll have through biosolids, through through other environmental factors, through contact with consumer goods products, as well as other non-PFAS related risk factors. So I think that the practical ability to determine and attribute a health outcome or to to compliance or non-compliance conditions in this bill would be really impossible. So those are my concerns with it. I know MES is also on, and as an agent of the state does manage some of these substances. So I just didn't know if if it's appropriate, Delegate, if it'd be appropriate to get their feedback too.
Sure. In a second, I'll call on Jeff Tosi to see if he has any feedback. But in the meantime, Delegate Grammer, you have a response?
Yeah, thank you, Mr. Chair. I just wanted to challenge that directly. You know, we've talked about PFAS quite a bit this session. And, you know, we know that as a matter of application, there are direct health consequences. That's why both the state, you know, the federal government and now the state vis-a-vis this bill are attempting to actually set a parts per billion. So I challenge that directly. But I will note what the amendment does not do. It does not get into the parts per billion. It just says if there is an industry partner that if a person who has an adverse health outcome, if that person or those persons, which it usually is, if they can prove in a court that this PFAS has been placed irresponsibly by a business interest, that they will be liable. So I actually I approach this differently. I think this amendment does not get into the parts per billion, but it does recognize the harm of this, you know, of this product. And it just holds industry accountable.
Delegate, can I ask you a quick question? Am I correct that you have a strict liability standard in there?
I don't actually think it is a strict liability. I can review it really quick.
I'm gonna bring it up too, so we can all review. I just took my screen off because I was getting a bunch of notifications. Let's see.
So I'm scanning through my amendments here.
Yeah, the page, for Roman numeral 2, a person is strictly liable for damages.
If that's in there, I stick by that
Okay.
because they are the source of the contaminant.
Okay, Delegate Odom? Delegate Odom, do you have your hand up? I'm sorry, you're on mute.
Yes, I had a question that, is there any active litigation locally or in the state, of course, or anywhere nearby that references rulings or any sort relative to PFAS?
Yeah, if I could speak to that, Delegate.
Sure.
Yeah, so the state is engaged right now to two litigations, one related specifically to AFFF, which is the firefighting foam, and one related to not all the other non-AFFF uses of PFAS, and these are specific to 3M and DuPont. And so we are actively in federal court seeking damages related to those historical contamination. And so yes, we are pursuing damages on behalf of the state in the courts. And by we, I mean the Attorney General on behalf of MDE.
And could I follow up?
Sure.
But we've not reached total settlement in any of those. So we don't have any basis of court rulings or anything like that we
Not yet. We've been working through jurisdictional questions in the courts so far.
Thank you.
Okay, Jeff Tosi of MES, and then Delegate Morgan, I'll call on you right after Jeff has a chance to comment.
Hey, thank you very much, Mr. Chair. Sorry, I'm a little bit under the weather because of the flu, but appreciate the opportunity to comment. So the first thing that I thought of when I saw the amendment was the concern that I would have was that it's attaching the liability to counties and local governments. And, you know, counties, local governments, MES operates wastewater treatment plants on behalf of local governments. We're passive receivers for the influent, and we're basically intermediaries between where it comes from and where it goes. And you know, I would be concerned that this would be opening up liability to local governments and the state. We have a significant industrial user law that's currently being implemented that's the aim of that law is to reduce PFAS from industrial sources, which is of high concentration of which the PFAS substances are coming from those sources. And so, I'm not 100% sure how this amendment would interact with the bill once implemented. But it just appeared to me that this would probably open MES and other state, local government agencies and entities up for liability because it's attaching the blame essentially onto the sewage sludge itself. But again, we're just passive receivers of this stuff, and all we're doing is trying to process and treat it, and then we're trying to get to a point where it can be both. I mean, there's really only two options right now that exist that are financially feasible for sewage sludge. And yes, there's one a third option, which is called the pyrolysis system. That would essentially bring it to extremely high temperatures, but those facilities are very, very expensive. We've attempted to get one through the capital budget process, and we've been unsuccessful over the past several years. They're very expensive. I know Baltimore City has one on a pilot basis right now, which is good. And I understand. We did visit it over the summer last interim. It's working well, but it treats a very small amount at this point, and compared to the overall volume of sewage sludge that's produced even at Back River. And so that would be my first thought, was that the bill seems to be the amendment seems to be attacking the problem from the wrong direction. And that we have a law in place right now that's attempting to bring these levels down. So that's where our concern would be for MES. And, I do want to echo what Zach had mentioned earlier as well, that there are just, other avenues that we can be taking right now to control the problem. Although this is not the best solution, the best solution would be zero. But this is the best that we have right now in terms of trying to blend together both advocates of the bill and entities that have to be treating the sewage sludge to the end. The two solutions that we have right now are basically land application and landfilling, and there's not enough landfilling or land application for each other to solve the problem. So there's no other way to really process sewage sludge at the moment. And so we've got to start someplace, and this is a very good start, and we hope to be able to bring these numbers down over the years. But that's, those are my comments right now, and it to me would be very concerning for local governments and for the state.
Okay, thank you, Jeff. Doug Morgan.
Thank you, Mr. Chair. Obviously, we've listened to PFAS here now with me for 4 years, and I understand the concerns. Before we had Charlie Otto here, who was a farmer, and now we have Delegate Anderson. So I guess my question here is, I understand the liability piece of it, but what concerns me is Delegate Anderson's concern as a farmer as to what this is, and is there any way possibly for Delegate Grammer to modify his amendment to take into consideration what Delegate Anderson has been getting at? And then thirdly, Delegate Anderson, I'm sure you probably haven't done this yet. Have you talked to the Farm Bureau? Because they came out in favor of this bill. And it's sort of like a competing interest here. The Farm Bureau is saying yay and you're saying nay. So it keeps me puzzled, for lack of a better word, not being a farmer. Bit concerned about the PFAS as it applies to, sludge and being put on the soil.
Yeah, Delegate Graham will give you a chance to answer that, but before that, Delegate Fraser-Hidalgo has his hand up.
Yeah, this is my first year hearing the bill. And so I would just say, did Mako have a position on this because I think the stuff that the issues that Mr. Tosi brought up are concerning to me. Not being a lawyer, they're concerning to me. So at this point, I just am very apprehensive about getting into. I'm not a lawyer, so I get very apprehensive about getting into a space that I'm uncomfortable with that I don't know. So, does anybody know whether Mako?
Yeah, I can tell you,
I'm bringing
Doug.
up the witness list right now.
Yeah, I mean, because had a chance to talk briefly with Mako just a
They're-
little while ago. They're non-favor of Delegate Grammer's amendments. They were part of all the discussions that led up to the amendments that are incorporated into the Senate bill, which are consensus amendments.
So they have the same concerns as Mr. Tosi's has stated.
I believe they would.
Okay. All right. Well, that's kind of my position. Just very concerned stepping into something. I'm not an attorney, and so.
Okay, Delegate Grammer.
Yes, thank you, Mr. Chair. I could speak directly to those 2 points. I will say, I think Mr. Tosi mischaracterizes the amendment, and I'd like to read one sentence which I think brings that home. A person that applies sewage sludge or products containing sewage sludge under subparagraph 1 of this paragraph is strictly liable for damages for any injury or loss to person or property that is caused by the activity. So I don't think this applies to the state at all. I don't think this applies to counties. I would have a concern if I thought that my own amendment applied to my county. It clearly only applies to industry players who are placing this product. And to address the question from Delegate Morgan, I have not talked to the farmers about this. This amendment is about people who might be harmed because this has been placed in a way that gets into the food and somehow harms a person that has no idea that PFAS may have been propagated through this process into food that people think are safe. So I would remind everybody there's a lot of people, including the farmers, who, have a bit of an interest in seeing this process continue, but I just think we should make sure without the ability to either have another process or reduce the parts per billion to 0, we should have a framework in place where industry partners are actually liable if someone's harmed.
Delegate Anderson, before calling you, Jeff, do you want to, I mean, my understanding is different than Delegate Grammer's about potential local government liability. I don't know if that's something that you can address or there's something else you wanted to add.
Yeah, I mean, I don't think I have, I'm not certainly an expert in litigation matters. I don't want to pretend to be one. So Delegate Grammer's point is well taken. However, I don't know how that would work and function when you have, and like MES has contracts for land application of biosolids. So we don't do the land application ourselves. There are companies out there that do this stuff. But how does that trace back to MES and to the local governments? I'm not really sure about that. So do those contracts then become void? Does that then become a problem where, let's say, for example, Delegate Grammer is correct and the liability doesn't go back to MES. Does that then chill the ability for MES to do any land application from that point on? And what happens when there's no opportunity for us to land apply? I realize that there's a very serious issue and we want to try to tackle it as best we can. But stopping land, one of the reasons that MES has been engaged in this process substantially over the past 2 years was because we would like to come to some sort of agreement with the industry and with advocates that strikes a balance, like Zach was saying earlier. If we were to, the bill last year started at 1 part per billion, and it was very clear last year that 1 part per billion is not achievable by any wastewater treatment standard. We cannot treat wastewater to remove PFAS down to 1 part per billion currently. We don't have the technology in place. So our conversation at that point was, well, then you're going to force local governments to have to ship it out of state, or you're going to force landfilling. And we already know that there's not enough landfill capacity in the state to accommodate basically another 53% of all of sewage sludge. So if we were to landfill 100%, there's no landfill capacity for that. So the conversation then was, we need to figure out how we can get to a point where we can treat PFAS or treat biosolids, keep land application in place, because there's no other alternative right now to get rid of this stuff. And so if we then have a system in place where it's going to place strict liability on the companies that do the land application, even though they're also just passive receivers of they're not generating PFAS, they're land applying.
Jeff, if I could ask you to wrap up, we're going to have to
yeah.
move
So
on from these amendments.
the bottom line is it might end up in a chilling effect for land application processes, and I'd be concerned about that as well.
Okay, thank you. I think we can give about 5 minutes more to discussion of these amendments. Then we're going to have to circle back to consideration of the amendments we discussed on Monday. So there are 5 people who have their hands up, going to ask to be as brief as possible, starting with Delegate Anderson.
I've learned through this discussion that the farmers of Maryland are doing a service to our community, and we're not being remunerated for it, but we're accepting all of the liability. And to Delegate Morgan's point, I can carry him to some farmers in Montgomery County that have gotten PFAS in their land from taking it out of DC, and they'll show you where it's really concerned, because I know of farm families in the Midwest that no longer can grow anything on their farms for the rest of their life or their children's life, because they've had too high rates of PFAS spread on their land that they weren't notified that the rates were high. And they can no longer grow. They can't even have horses, cows. There's nothing that can be produced off that land. And that's a concern to me. Thank you.
Okay, Delegate Grammer, last bite at the apple, and please be brief.
Yes, sir. And I really appreciate this vigorous debate. I actually think Jeff nailed it. I love Jeff. I think if a player in the industry is moving this product in a way, and they know they're liable, they will say, wow, we better take a good look at this to make sure, even though we're working within the statutory framework, that the end user will not be harmed. And members of the committee, those people are depending upon us in this moment to look at this in a way that we could say, we know this is being applied to people's food in a way that is not harming their health. So I think if the end result of this liability application is that all the players who may be contributing to the distribution of this material realize there's some liability, I think that's a good thing. With that, I'd move the amendment, and I'd hope for a second and support from the subcommittee.
Sure. Not yet. We're not moving any amendments, not yet, but we'll get there soon. Delegate Fraser Hidalgo.
Yeah, I saw Dominic Butchko from Mako jump on, so that's why I put my hand down, but then he put his hand down. I don't know why, but I had originally asked what their position was. If it's okay, Mr. Chair, I'd like to just briefly hear if they have a position, because I asked before and we didn't have as much clarity as I'd like on this specific amendment. Thank you.
Dom, you want to weigh in?
Yeah, so thank you, Mr. Chair. I saw you were wrapping up. That's why I put my hand down. So just really quick, this bill is the product of months of really intense work between the advocates, between the counties, between the utilities, et cetera. What this amendment would do, very clear, black and white, it would raise rates on water utilities. All of this infrastructure is funded by ratepayers. And so if there's going to be anything that makes the operation of that infrastructure more expensive, there'll be a very quick, very clear increase in what the water rates are going to be. This is a long, hard fought compromise. Not everybody is happy with it. I think MACO would urge to resist this amendment right now.
Okay, thank you. All right, so thanks for the good discussion about this amendment. What I want to do is go back to the amendments we discussed a couple days ago, the amendments that have been put onto the Senate bill and approved by the Senate, which I support, and we discussed on Monday. So Kristen, can you pull those up?
Sure.
So just to summarize, and Kristen, feel free to correct me, what these amendments do is they set a structure saying that anything with PFAS level of 50 parts per billion cannot be land applied. Anything under 25 is assumed, that you can continue to land apply. Between 25 and 50, it sets up a structure for remediation of that sewage sludge. And it triggers federal authorities to go back to that allow us to go back to the sources of the PFAS so that and the authority to say, okay, source of the PFAS that's going into the wastewater system, you need to remove or reduce the PFAS in your waste stream. Is that a fair summary, Kristen, and Zach also, who is the
Yeah, I would defer to Zach if there's anything else that's notable to mention about the bill.
No, that was a good summary, Delegate.
Okay. Any questions about, again, we discussed these a couple days ago. Any questions at this point about these amendments? Is there a motion on the amendments?
So moved.
Is there a second?
Second.
Thank you. Okay, all those in favor of these amendments say aye, or why don't we do raise your hand literally or through Zoom. Let's see. Ian, could you help me count, please? 1, 2, let's see. Is that 5? I think.
I feel like mine went out of order, so let's go 1, 2, 3, 4.
I think I see
7.
6 or
I think I
7.
see
Okay.
7.
Okay.
7.
7.
7. Okay, opposed? Any opposed? Okay, so these amendments are adopted. Kristen, there was one other, I wouldn't say it's a technical amendment, but other amendment, which is a sponsor amendment. Senate agrees with it as well. Could you pull that up?
I was trying to do a side by side here. Let me see if I can. So here's language that is being proposed to replace the new new G paragraph 2 after line 25. I don't know if this is the best way to do it or not, but
Okay.
if you want me to show one in full screen, like this is the amendment
Yeah, it's again sort of, you said G2.
E2, yep.
Right. Okay. And Zach, can I ask you, since quite honestly, I'm not entirely familiar with the rationale for this change, could you explain it?
Yeah, I think it was because the intent of the discussions had between the utilities, the advocates, the department, others, was that rather than having it be a date certain, it would be from from a year, 12 months from the date of application, or from the date that a 12-month average triggered these requirements.
Right. I mean, do you want to talk about this mass balance calculation? I mean, how
Yeah,
that,
it's just
yeah.
in the event that a commingling operation doesn't have, because the commingling operations don't have the same monitoring requirements that the utilities themselves do.
Mm-hmm.
But all of the biosolids being moved into a commingling facility are coming from utilities that will have that 12 months worth of samples. And so the commingling operation would use a weighted average of the PFAS level per mass, or per the volume of PFAS of each of the source facilities would be averaged to determine what the level of PFAS in that commingling facility would be for the first year, until that commingling facility has a sufficient group of samples directly to base their level of PFAS on.
Okay. All
So
right.
it's mass
I
balance
get it.
is a weighted average.
Right. Okay. Makes sense. Any questions about this amendment? Is there a motion on this amendment?
So moved.
Move the amendment, Mr. Chair.
Okay. All those in favor of the amendment, say aye.
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 Opposed? Okay. That amendment passes as well. Okay, so now we have Delegate Grammer's amendments. First, I just want to say, is there a motion? Delegate Grammer, you have moved your amendments. Is there a second?
I'll second his motion.
Okay. Give a few more minutes for discussion. I will say, I obviously I'm the sponsor of this bill. I'm opposed to the amendment because for a few reasons. First, as Mako has said, and really this was more on the Senate side, but there were months of discussions among all the stakeholders, including, environmental advocates, local governments, as well as industry, that came to a consensus with respect to this bill and the amendments as been adopted. Is it perfect? No, but it is a big step in the right direction. Right now, there are no limits on PFAS distribution, sewage sludge. This does set limits. It triggers federal authorities to get to the source. And I'm worried that this amendment would sort of undermine that consensus, lead to elimination of all applications of sewage sludge, whether it's PFAS free or not. And secondly, I generally just don't like when there's a strict liability provision in a bill. But with that, open it up to further discussion. Delegate Grammer.
Thank you, Mr. Chair. And again, I really appreciate the opportunity for discussion here. So I understand that there was a lot of discussion about this. But in the end, if the discussion leads to a bill that doesn't actually change what we do for the better, shouldn't we do a little bit more? And I'll ask the subcommittee to keep in mind that it seems like most of the people in the discussion have an interest in kind of perpetuating what is already happening. And as discussed in the bill hearing, this doesn't practically change what we're doing at all. We're not actually requiring any additional remediation of PFAS in this product, for which there tends to be a large economic benefit for a lot of people. I'm sure the farmers want to continue to see this placed. Clearly, the industry players who are profiting from this product want to see the current structure put in place, and that's what the bill does. So That's why, this civil liability solution that I've offered, I think it's actually a very elegant solution. And it says if there is an actual harm caused by the placement, like, look, we could pass this amendment and nothing ever happens. There are no actual litigation brought because the industry is tightened up. They said, we know we're liable. We're going to go beyond what the statutory framework does to ensure that when we apply this, it's done in a safe way. And I frankly, think that's a pretty elegant solution. So I think it's a good amendment. I think if what Mr. Butchko says happens and water rates increase because, there is a push to kind of tighten up what we're doing, I think that frankly, I'm not opposed to that. Because in the end, what we've spent a lot of time this session talking about is the fact that this stuff is poison. And as, representatives of the people of the state, I think we should do the right thing and ensure that if in the end this poison is applied to our farms in which we grow our food, there is a liability for people that have done so in a way that is harmful. So with that, I'll be agreeing, and hopefully the subcommittee will be as well. Thank you.
Yeah, Delegate, I appreciate your passion on the subject and understand where you're coming from. I just will have to disagree with what the bill does. Right now, there are no limits on PFAS concentration in sewage sludge. This sets a clear limit, and with respect to intermediate concentrations, it says it has to be remediated, where after a certain period of time, you can't apply it anymore. And also, it triggers federal authorities, which can get at the sources of PFAS that are going into our waste stream, which otherwise, without this bill, wouldn't happen. But anyway, that's my final comment on the bill and the amendments. Certainly, other comments are welcome if anyone wants to raise their hand. Okay, with no comments, then we'll go to a vote. The motion is on the floor is favorable for Delegate Grammer's amendments. All those in favor of Delegate Grammer's amendments, raise your hand. Okay. If you could help me count.
I think I have two.
Count three. Delegate Anderson, Delegate Morgan, Delegate Grammer.
Yeah.
Okay. All right, oppose.
I count five.
5. Okay. Motion fails. Amendments are not added. So what we have now is a bill that's been amended with, a fair number of amendments representing, what has been passed on the Senate side. And again, I consider them to be sponsor amendments, plus the additional amendment concerning the smaller amendment that we just discussed. Is there a motion for the bill as amended?
Move the bill.
Second.
Okay. All those in favor, raise your hand. Okay, Ian, what count do you have?
I count 7. 2.
Okay. All right, thank you. Opposed?
Count 1.
Okay, any abstentions? All right, well, thank you. We are done with our agenda for today. Thank you, everyone, for the spirited discussion. And this may not be the last meeting of the week for the subcommittee. We're still 5 days away from crossover. So it, could very well be that we'll have another meeting later this week. Obviously, we will give you as much advance notice as possible, but just stay tuned. And with that, we are adjourned.